Welcome back to the program. Peter Shamshiri, Lawboy on Twitter, the Dying Mall that we've been told, the Dying Mall by Bobby Bigwheel, and co-host of the 5-4 podcast, which I guess, did you guys ever contemplate changing your name after it became 6-3?
No, but everyone tells us that we should. Our position has always been that the 5-4 is more of a symbolic sort of thing. It's not really about the split per se, although we had to really dig in our heels on the symbolic element after it became 6-3.
There you go. All right. Well, and it's also, I guess, hopeful in some way. But anyways. All right. So 3 cases I want to talk to you about. 2 of which have heard oral arguments. The third has just been sort of accepted for review by the Supreme Court. We'll get to that in a moment. But let's start with student loans. Start, if you will, with the legal authority in which, because there's some controversy about what legal authority the Biden administration chose to use, because they had options to essentially offer this student loan debt relief, $10,000 per person under $125,000, $20,000 if it was from a Pell Grant. We should just say something like this is going to impact like something like 45 million people or so, somewhere around there, and 16 million already had theirs approved. Another 16 million were already in the system. Nobody's gotten their loans because of this lawsuit. Go from there, Peter.
Sure. Yeah. So the Biden administration has chosen to use the HEROES Act as their authority for forgiving the loans. The HEROES Act is a 2003 law that authorizes them to waive or modify any statutory or regulatory provision applicable to the student loan program in emergency situations. So it's sort of tied to the fact that the pandemic impacted everyone's economic situation, and that is why they're doing it. This is the authority they used also to pause loan payments, and it seems sort of in line with their current philosophy that they're sort of angling it as a pandemic thing. There was the option of going with the Higher Education Act of 1965, which is not tied to emergencies and also sort of has this sort of broad language saying that they can forfeit any right to related to the loan program. So they had multiple options. They went with the sort of pandemic-oriented HEROES Act.
Now, let me just say this as a political matter and a policy matter. I would have preferred them to do the latter because, and I'm quite convinced they did the former because they wanted it to be a special thing and they didn't want to give anybody any ideas for the future. It's almost in the same way that the Democrats said, we're going to pay for free COBRA as opposed to having people be in Medicare, even if it was temporarily, because they didn't want to give anybody any ideas. But putting that aside, my preference would have been, let's just use the authority that exists there and test that as opposed to this emergency authority. Putting that aside, let's talk about it from a legal standpoint. And then we'll get to the standing of the parties, et cetera. But when they went to the court and we heard the oral arguments, did we hear anything from the justices that they took issue with the definition of an emergency, right? Like it was an emergency in 2020 when Trump paused these loans, but it's not really an emergency today. And B, did those justices or any of the justices reference the other authority that the Biden administration could be operating under?
Yeah, so they actually didn't really make a big stink about it in oral argument. People thought that they might, especially because the administration is saying that the emergency is ending. The administration has sort of waffled on other issues like the impact of the emergency on immigration policy, for example. It was something that certain amicus briefs touched on, basically saying they're trying to have it both ways. The emergency's over, but it's not over. The Biden administration's response to that had always been, this is still related to the emergency because the economic impact lingers. And I think that argument resonated. And so no one at the court seemed to be particularly convinced. And I also think that from the justice's perspective, you can sort of see that they feel like they don't need to go there in sort of arguing about the gray area of what an emergency is, where it ends. That is a lot trickier from their perspective than just ignoring that and arguing about the merits. Does the Secretary of Education have the authority to do this? So they didn't really confront it much. There were only passing references to other authorities. And in large part, they focused on, besides the standing issue, which, as you referenced, was really the big issue. They really focused on the language of the statute and the major questions doctrine, which has been haunting administrative agencies for the last few years.
Okay, so let's return to that aspect of it, because that becomes a Chevron doctrine versus the major questions doctrine fight, and we'll return to that in a second and go to the standings, because I want to when we return to that Chevron doctrine, major questions doctrine question, I want to both address like the way that they're approaching it and talk about how ridiculous the major questions doctrine is, but whether or not that could have also been deployed against the other law, because at the end of the day, the major questions doctrine is designed to basically say, we get to decide, regardless of what it is. All right, so let's get to standing. There are two cases here. One is brought by 6 states or 7 states.
6 states, right?
And one is brought by 2 people. Let's start with the 2 people one, because that one everybody seems to think is an absolute joke.
That is my position. I think that they have a really sort of ludicrous claim to standing. I mean, standing, again, is just this legal idea that to bring a lawsuit, you need to have been injured. And courts have always held that that injury needs to be something relatively discreet and direct. What they're claiming is essentially, well, we didn't get loan forgiveness. We didn't qualify for the loan forgiveness that we wanted under the Biden program, and we want it, and other people got it. And so is that not an injury? And the reason that people think that this is silly is because there's, just a sort of common sense difference between being injured and not receiving a benefit that someone else received. But that's sort of the heart of their claim here. They're making like a technical procedural argument at the bottom of it, asking for notice and comment. But I mean, the heart of their standing claim is it just doesn't make any sense to me. Yeah.
Hey, and if I remember, I mean, I had 1 year of law school, so I did take civil procedure. And if I remember, you also need to be pursuing a relief or a remedy that is going to deal with the injury that you have gotten, right? So, if I get hit by a car and I break my leg, I need some cash, because one of the things I've suffered is not only all my medical bills, but maybe I have future potential earnings. So I want cash, and that cash is going to deal with it. They're going in there and arguing the bill is, we are injured because we don't qualify for these things. I didn't get a Pell Grant, I think, in one instance, or my loan was from a private company, not the government. And so the remedy, the way to fix this, is to give no one any debt relief. Wasn't this one of the big issues too in the moot court? Like you said, I can't remember which justice said, like, you've come in here.
I think it was Kagan who basically said, even if we sort of grant that you're injured, what you're asking for is functionally to halt this program. So how does that help you at all? You're now no one gets anything. And is that really a remedy to the problem, to the injury that you're claiming? Their response was sort of this vague, well, what we really want at the end of the day is for the Biden administration to scrap this program and then reconsider one that would maybe potentially benefit us. So they have that sort of tenuous roundabout argument to say that they are in fact seeking a remedy that would help them, but it's the only remedy that they're actually seeking is for the Biden administration to scrap the program. So yeah, it just doesn't make much sense.
So let's go to the other, and keeping in mind those three elements of that you need for standing, which is a direct harm and a remedy that's going to redress your thing, and a direct, well, an obvious injury and a direct connection to what the government did in that injury and a redress. We have these 7 states or 6 states, and they also got a problem here too with that, it seems. But go ahead, explain.
Yeah. So the states they have their own little claims to injury in each case, but the most interesting one, the one that most of the argument focused on, was Missouri's. Missouri has their own state student loan authority, MOHELA, I think is the acronym. And what they're claiming is that program, that authority, is injured because the forgiveness will result in debt holders consolidating their outstanding debt, which will take money away from the state loan authority. And the state loan authority provides their revenue to the state's higher education fund at the end of the day. So you have somewhere downstream of loan forgiveness is less money in state coffers. And that is sort of the Missouri argument. There are a couple of problems with this. One is it's a daisy chain to get there, right? It's not really a direct injury. They haven't done a ton to show that they know for sure this will happen or to what extent it will happen. The other problem, and this is really probably the biggest problem for them, is that MOHELA, the state loan authority, is a separate legal entity that governs itself to a degree, and could, if it wanted to, bring this lawsuit on its own behalf, and in fact brings lawsuits from time to time on its own behalf in other matters. And so what the court brought up, I think it was Amy Coney Barrett actually, who brought this up, was, well, this isn't really you who's being injured, right? This isn't really Missouri. You have this separately legally incorporated entity. They didn't want to bring this lawsuit, so why are you standing in for them? And Missouri had a sort of roundabout response again, where they said, well, they're sort of an arm of the state. And Amy Coney Barrett fired back, well, then you could have made them sue, right? And they didn't have a great response for that. And again, I think this is the state with the best claim to standing here.
Right.
So it is very shaky, although some of the conservatives, especially Alito, seemed very willing to just sort of hand wave this away as like a legal formality, something that's sort of beside the point at the end of the day. But, the other states have even weaker sort of positions here. They're claiming that one day in the future, in a couple of years, they're going to start taxing the discharge of student loan debts by the federal government. And so this is denying them that tax revenue. It's all very tenuous. The only thing that they have going for them is that historically courts have been relatively lenient on states in these situations. That said, it's also been sort of long rejected, the idea that states can just challenge federal policies by pointing to their tax revenue. Because if that was enough to grant standing, any state could really challenge any federal policy. Almost all federal policies are going to have some sort of impact on tax revenue at the end of the day. So the conservatives on the court, with the exception of Amy Coney Barrett, I think seemed pretty willing to entertain this. But as far as traditional standing analysis goes, it didn't seem like they had anything. It's
super dodgy, it seems to me. I mean, super dodgy. And so getting past the standing thing, which really should be the thing that kills this, right? Yeah. And it does seem like the Biden administration almost relied on that on some level. They're like, in fact, they made some changes in September. They got rid of they sort of skirted around the private administration of the private servicing of loans, so that they could avoid the standing that might come from like a company that actually services and says, we're losing money because we take a fee on that 10 grand and we're losing money. They eliminated that aspect of it to avoid the standing. That seems to be their legal strategy, was that this is going to die on the vine because of standing.
Absolutely. I think that, as a lot of people have criticized them for going in a little bit sloppy using the HEROES Act. They did this now classic Biden administration thing where last summer they were talking about how they weren't sure that this was legal, and then they try it anyway. And so then, you get to hold their own words against them.
Right.
But the one thing you can give them credit for here is I do think that they were laser focused on building a program that would be difficult to challenge from this perspective. I think it was as the program was being announced, Ted Cruz was tweeting, look, we're trying to sue, but we need a theory of standing first. And I think that's as good of an admission as you'll ever see from the conservative legal movement, that the Biden administration created a real problem here for them. So I do think it was a big part of their strategy. I do think that it was sort of the spearhead, because they knew that if it gets through to the court on the merits, they're probably in trouble.
And based upon let's get to the merits, because this is the difference between the Chevron doctrine and the major questions doctrine. Will you explain to people, hopefully at least a significant portion of our audience at this point understands what the Chevron doctrine is and the major questions doctrine. I would consider it an abject failure on my part if they didn't at this point. But that aside, will you just explain these two principles? Yeah. Because one is really, it seems to me, the major questions doctrine is basically just like, you and what army are going to do anything about it? We're going to decide this way, and we could do it on anything.
Yeah. So the Chevron doctrine is this idea that when you're interpreting administrative agency action, when you're trying to figure out if an administrative agency is working within the scope of their allocated power, the power allocated to them by Congress, you generally defer to the agency itself. That was sort of the rule until a few years ago, with very minor exceptions. The major questions doctrine is something that this court has made prominent, where they basically say, we're no longer going to defer to agencies on issues of vast economic and political significance, which I think to them means like whatever Fox News thinks is a big deal. That's honestly my read on it. It's sort of, it's something that lacks any clear direction. They don't have any like objective criteria for what that means.
But like, could they? Because isn't it almost definitionally, like a federal government agency, really, like, unless they're just like, how many staplers should we have in the office? They're going to be deciding something that's going to have major implications for society, right? It's just a joke. And we should say, not only has this court embraced it, it just sort of came up out of nowhere in the past, like 15 years. It didn't exist.
Right. It traces back to a 2000 case where the court just sort of used this language in a case about the FDA. It quickly became irrelevant because Congress passed a statute. And then it was functionally dormant until maybe 2 years ago, and really hit its stride in the eviction moratorium case. And all the pandemic, basically the pandemic related rulemaking is when the court jumped into action about this. It is, I don't want to get too cute with it. It's made up, right? The entire concept is too vague to have any meaning. It's just an excuse for the court to be able to step in when they have policy concerns. And I think you can see that in the oral argument. They're having these arguments about policy, about whether the policy is fair, which is just so far beyond the scope of what should be the court's analysis here. And so I think that's what's happening at the end of the day. They didn't like how much authority the executive branch was getting using the Chevron doctrine. And so they created an exception and just blew a hole in it.
And we should say that the they don't make an argument about the merits of deciding whether it's an emergency. That would have been very tough, particularly we still have stuff that 9/11, frankly, implicates 20 years later. There's no emergency associated with 9/11 anymore, but things that came out of that emergency still are valid. Like you say there, and just to be clear for people, when you say that they're arguing policy, they're arguing whether this is a good idea or not, or whether it's fair, not whether it's legal. And up until really it became 5-4 conservative, there was this whole concept that we just got hammered on, like judicial activism, which was sort of a made up concept. But to the extent that it exists anywhere, it should be that the policy, the only time that you consider whether it's good policy is if its implications run afoul of the Constitution, right? That's the only time that you're supposed to consider policy, is not sort of like itself as to whether it's fair or good or this and that. It's that the outcomes it generates, would those run afoul of a legal principle? And they're not doing any of that here.
No, I mean, even given what this court has done in these cases so far, this oral argument was particularly focused on just whether they thought this was a good idea. You had Sam Alito basically hammering home, is this fair? What about someone who runs who didn't go to college but runs a small company and they're not getting any assistance? How do you justify that? Even by the standards of Sam Alito, I think people who are court watchers were sort of caught off guard by just how politics and policy driven the questions got at certain times. John Roberts was asking,
and we should say the solicitor, the representing the government, responded by saying, "Well, Congress passed a law that empowered the Secretary of Education to do this. They didn't pass a law that empowered anybody else to relieve the loans of a lawn care business." And that's the point, right? Like, these guys are like, what does the law say? And they just have an issue. They did this, frankly, with the Voting Rights Act in 2013. They said, Congress voted for it, but they didn't really mean it. And I guess the point here is, had the Biden administration, based upon what we heard in this moot court, had the Biden administration used a different authority, specifically the Higher Education Act of 1965, which says the Secretary of Education has the same power that he has under the HEROES Act, essentially, but just without an emergency. It seems to me that this court could have deployed the exact same arguments, because the only issue is, we just don't think you should be doing this.
Yeah, that's my read on it. I think that people who were skeptical of the HEROES Act as the basis were convinced that it gave the court an angle to attack it. You all of a sudden they have this additional argument, the emergency argument, and I think that was a little bit misguided as a critique, because they don't need the emergency argument. All they need to say is, well, this statute isn't specific enough. It doesn't specifically say that you can forgive these loans in X amount or whatever, and therefore it's not adequately clear as a statute, and the Department of Education doesn't have this authority. That's all they need, and I think they have that for the Higher Education Act too. So I don't think that it would have made a difference. Maybe that's wrong. Maybe there's some nuance in the statute that the conservatives would have been convinced by, but I doubt it.
Lastly, in the American Rescue Act of 2021, Congress also said that any student debt relief up until 2025 is considered non-taxable, essentially a service in kind that is non-taxable. I don't know what the phrasing would be, but isn't that also more indication that Congress completely contemplated this action, regardless of which authority the administration used, this action to take place? And because they didn't put a threshold on it, also basically conceded that it's up to the Department of Education to make this assessment.
I think that it does indicate that Congress contemplated it. And I also think that we don't even need to go that far, right? The entire purpose of the HEROES Act was to create a little bit of leeway for emergency situations when action was needed. And they didn't know what emergencies were going in 2003, what emergencies were going to develop over the course of the next quarter century or whatever. And so the breadth the breadth of the statute and the lack of specificity is a feature, not a bug. And the Supreme Court is treating it as if it were a bug, and sort of holding the broad nature of the statute, of the grant of authority to the executive branch, against it.
And last question on this, because the people need to understand. I mean, if this case goes down in the way that it appears that it's going to, like, it becomes increasingly hard to imagine what can be done in the future. For instance, if Congress has a will for a single payer health insurance program, they're not going to sit there and work out, what are the payments going to be to this entity? What are the payments going to be? How are they going to calculate it this way? How are you going to go about doing it? They're going to write a statute, and this is the way that it's been done all the time. We're going to write a statute that has broad principles and broad ideas, maybe some specifics in certain areas, but we're going to leave it up to Health and Human Services, for instance, on how to execute these broad principles. And a case like this basically says that the court can go in and go like, this is a big deal. You know, health insurance, it's 1/4 of the economy or whatever it is. Like, the agency can't figure these things out. You need Congress to do every one of these. How much are you going to charge for a hip replacement? They're going to make it impossible to pass any programs like this.
Yeah, they've been using this major questions doctrine to attack some policies that are frankly not that big of a deal, right? They last year used it to go at an EPA policy that wasn't even in effect. So when it comes to a really truly broad welfare program, for example, I just can't see it surviving this court in any form, no matter how careful Congress is.
And let me ask you this too. I'm sorry. Is that what they're doing? Like, in other words, these cases are important. You know, the fact that it was done under the emergency provision means that if you are a justice and you're worried, like, I don't want the government to be relieving debt in the future, they're not going to be able to do it in the future under that provision. But are they not just creating essentially a history of the use of this doctrine so that they can deploy it when they need it?
I think that's exactly what they're doing. They are consolidating power in themselves. And I think they are doing that with the knowledge and understanding that they're going to control the court for the next couple of decades, most likely. And this will be an effective tool against policies they don't like.
It's so effed up that I almost want to just not even talk about the other cases. Honestly, it's just, it is just so effed up. And it was predictable. I mean, it was sort of predictable. I mean, these guys have been going there for a whole time. We can get to 2:30 in a second. The court also, just because this has to do with this as well on some level, the court accepted to hear a case as to the constitutionality of the Consumer Financial Protection Bureau. Yeah. And they're arguing it's under, and we don't know what the court feels about it, but the lower court said, because this is funded in a way that is unique, but especially unique, right? Because we have unique funding for agencies, but this is unique-y, I guess. Will you explain why this is even a case?
I'm not entirely sure that I can answer why it's a case, but I can tell you what the Fifth Circuit said.
Yes.
So the CFPB is funded through the Federal Reserve. The Fed gets its funding from bank fees primarily, and then what Congress did with the CFPB was say, well, you make a request for your budget to the Fed, which sort of ties the CFPB to the banks that it's largely regulating and keeps it insulated from certain political maneuvering. So the CFPB will make a request to the Fed. It's capped based on certain operating expenses of the Fed and inflation, and then the Fed writes it a check.
And we should say that mechanism, the idea with that is that it's done so because it's supposed to sort of somewhat reflect the size of the banking industry, right? Like it's as the banking industry grows, the budget for the CFPB can grow. As the banking industry contracts, it won't. The CFPB can contract.
Right. And yeah, I mean, the Fifth Circuit has basically put out what I think is an oddly vague decision, saying that this is unconstitutional under the Appropriations Clause, which the Appropriations Clause just says, no money shall be drawn from the Treasury, but in consequence of appropriations made by law. So the Fifth Circuit's position is whatever this is, it's not an appropriation. Now, why they think that is genuinely unclear, even if you read the decision. It seems to me that what they're saying is this is so weird, so unlike any other agency, that it's not an appropriation. But it's at no point did they say, here's the sort of dispositive element that makes this not an appropriation. They just sort of go through the various unique features of it, and it is a relatively unique funding structure. So they're sort of correct in that sense. But then they make this odd leap to saying, well, it's not an appropriation, which the CFPB basically responded saying, Congress passed a law. It provides for an amount of money. It caps that amount of money. It provides for where the money comes from. What else do you want here, right? The Government Accountability Office has definitions of an appropriation that seem to match what they're doing. The Supreme Court has never held that appropriations can't take a form like this or even come close to holding that. So it seems to me like the Fifth Circuit was just taking a swing. Let's see where we can go with this. And I've learned my lesson about saying things like this won't work, so I'm not going to say it. But it did immediately hit me as a little bit absurd, and it would be tough for the court to create a rule that just took out the CFPB without taking out a whole host of agencies along with it, which they might not be afraid of.
Right. And is it an appropriation from Treasury?
So the Constitution says no money shall be drawn from the Treasury, but in consequence of appropriations made by law. So that's all we have. It depends how broadly you want to read an appropriation, how broadly you want to read the term Treasury, right? Are we just talking about all the funds in the government's possession, or are we talking about something specific? So I think it really just feels like fun with definitions that the Fifth Circuit is having here. Basically saying, well, what is an appropriation? And that's a question that the Supreme Court has never really tackled head on.
And why do you think the Supreme Court took this? Is it just the Fifth Circuit wouldn't be determinative, right? I mean, the Fifth Circuit doesn't have the ability to shut down the Consumer Financial Protection Bureau, do they?
I mean, they can certainly. What they have claimed is that this is targeted towards this one 2017 rule and is not a broad swipe at the CFPB. What they have done is now create precedent that could be used to attack the CFPB as a whole. If this ruling were upheld by the Supreme Court, CFPB rules would be null. They wouldn't be able to pass any more. So it would be functionally not there. So as it stands, the Fifth Circuit's position is, well, this is just this one rule. But if we were to accept this precedent, it could be used to attack every CFPB rule. The Supreme Court will intervene before the Fifth Circuit gets to do that. As to why the Supreme Court took it, I think the optimistic view is that they were like, well, come on,
let's get rid of this. Let's get rid of this, and you guys in the Fifth Circuit need to just like chill a little bit.
Yeah. The pessimistic view is that they were sort of like, well, this looks like fun, let's take a swing at one of the newest federal agencies, like Liz Warren's pet project or whatever, and see what sort of damage we can do to their ability to
ever since Alito said that thing about Indian heritage, it's not inconceivable to me that he's just like, let's mess with her a little bit.
Yeah.
All right. Lastly, Section 230. This was argued in late February. This is a section of the 1996 Communications Act, maybe. I think
Communications Decency Act. Yeah.
Communications Decency Act. Section 230 basically says that if you are a website, not a publisher, but a platform, that you don't have civil liability for stuff that gets posted onto that site. You may want to police it because of advertising and what people say, cancel culture, I guess. But you don't have any civil liability. I personally think that Congress needs to revisit this, not necessarily eliminate it, but we need to tweak this thing. But this case is not going to be helpful in that respect, is it?
It doesn't look like it. What this case is about is ISIS, right? The case is brought by the estate of a U.S. citizen who was killed by ISIS in the Paris attacks in 2015. And what they're arguing is that Google, which owns YouTube, of course, should be liable under anti-terrorism laws for the role that the YouTube recommendation algorithm plays in radicalizing terrorists. So as much as Section 230 has become sort of a weird culture war proxy fight, there's an interesting legal question here about whether these types of algorithms that now dominate the internet, where they fit into the Section 230 scheme, right? Because the Section 230 scheme, like you mentioned, is 1996. It was designed really with like old school message boards in mind, right? And that's, so you have a website who plays a very passive role, and users are just posting in chronological order on the site. And whatever you think about, social media websites and what their role is and what their liability should be, it's certainly different than that, right? They have these algorithms that are not quite passive.
And we should say these algorithms are at their essence are developed to make money.
Right.
They are there basically saying it is, and this is the thing, this is the analogy in my mind is that there was a story, I think it was in ProPublica, about landlords raising their rents and basically there's an attempt to say there's some collusion going on because some company put out basically an algorithm which told people how to raise all of the landlords to raise their rents. And there's some price collusion going on. If you or I were a business consultant, and I said like, look, I'm talking to everybody and we're all going to raise our rents. If we all know we're using the algorithm that's telling us to raise the rents, there's really not that much of a difference. And so the algorithm is not just some rando thing that feeds up stuff based upon what you want. It's feeding stuff up so that these companies can make more money. And on some level, it's the same thing of like, when I put this story in the right-hand column because I want to sell papers type of thing.
Right. Yeah, and I actually think that's sort of Google's best argument, right? Is that they're going to make this argument that to some degree the algorithm is content neutral, in that it is just promoting what it thinks the user wants to see, whatever that might be. And sometimes it's something awful. They hope it's not, but so be it. They are sort of in a passive position here, similar to the message board host or whoever. It was very clear at the court that they didn't know what to do with this. You're deep in almost philosophical questions about what an algorithm is, and whether one can be neutral, etc. They were in way over their heads. I got the general sense that the conservatives had a sort of dog who caught the car vibe during these arguments. A lot of the conservative complaints about Section 230 sort of grow out of this sense that they are treated unfairly on tech platforms, that they are over moderated relative to liberals or whatever. And so there's been sort of a push on the right that migrated into the legal movement to attack Section 230. And then they, I think, thought they found a compelling hook in these ISIS cases, because you're no longer talking about something petty.
Right.
You're talking about something that really is a social concern. And then it gets to the court, and they're pretty plainly over their heads. I mean, almost none of them have any real grasp of how these algorithms function, what kind of rules you could pass to make them function differently, if that's even a possibility. You had Brett Kavanaugh talking about the economic cost of trying to do something here. I think they realize that they're in over their heads. So I would sort of expect them to punt on this one, although you never know.
Right. All right. Well, Peter Shamshiri, Law Boy on Twitter and co-host of the 5-4 podcast. Thanks so much for your time today. I think, the bottom line is the student debt issue is not only going to have implications for the 40 some odd million people who were hoping to get some type of student debt relief, and then all the knock-on impacts it would have on our economy in a positive way, but also it's going to have real implications for even more ambitious legislation if we're ever in a position to pass it. And it's a crap show.
It is. Thanks for having me, Sam. I appreciate it.
Thanks, Peter. Appreciate it.